Let's do this. Hey, this is Bill Gross, and welcome to Probate Weekly. We get together every week with leading professionals in probate and avoiding probate estate planning. I think of probate as you forgot to build the barn or you left the door open. And estate planning is building a barn that's secure with cameras and lights, hopefully to keep yourself out of probate. Out of Houston, Texas, we're excited today to have John Strohmeyer, whose motto I love is no unfinished business. John, thanks for joining us today. I know it's your phrase and you've trademarked it. What does no unfinished business mean to you?
So, Bill, thanks. It's great to be here. No unfinished business really is what we're looking for. It starts for probate of like, look, we're going to have all of this work to do, tying up loose ends for whoever you've lost. And probate, whether it's the formal probate process or just collecting beneficiary designated assets, dividing up the personal property, it's all kind of that stuff to do that we just want to make sure that when you've lost somebody, we're not leaving anything behind. Taking it back to the planning, well, we don't want to leave anything behind there. We want to make sure that we've taken care of beneficiary designations. How can we make sure that our clients who are busy people and aren't going to get to everything tomorrow just because we told them, hey, update your beneficiary designations or make sure this gets funded into the trust? How can we set it up so that they're taking care of that work?
I'm in a large estate now, about $40 million estate, but this is a common practice as a real estate agent where you ask a customer, hey, notice that your property is not in a trust. Have you considered an estate plan? They go, oh, no, I have one. And my heart sinks because I know what's going to happen. They go back to their living room or wherever and grab the binder that's beautiful. It's like leather, fake leather, all kinds of papers in there, but they didn't sign the signature page or record the document that should have been recorded. I see that all the time. And so that's the unfinished business. So I have to say, though, for those watching, if you go to his website, strohmeyerlaw.com, he has this absolutely forced me to click on the 4 Horsemen of the estate planning apocalypse. And I love that phrase, and it forced me to click on it, and I thought it was very helpful in terms of explaining what I think are the most common issues. So let's go to that real quick and use that maybe as a outline of our talk today. So the 4 horsemen, or maybe the 4 major problems that you're trying to avoid through estate planning. Number 1 is potential cost storms you have to weather. Talk about the costs that come up to people who don't anticipate or don't understand absent a proper plan.
Yeah, and so Bill, this is where I love metaphors, and I love probably even more mixing and matching metaphors. So the 4 horsemen came up with just kind of categorizing all of these problems. And they come down to a few things, and sure, some of them will overlap. But also storms you must weather. I'm going to turn my camera ever so slightly, and what you can see is I've got these maps that I've got on the wall. I had those done a few years ago just as a way of explaining the process. So one is a map for what the probate process looks like. The other is a map for what the estate planning process looks like with us. And so it comes back to this kind of sub-nautical theme that I layer on things, not in a kitschy way, like I'm not showing up with my my peg leg and my tricorn hat or whatever.
Maybe you should.
Maybe I should. But then, coming in, all right, well, here we've got to deal with this. So costs. There's just going to be a certain amount of cost that we have to deal with in any estate. Now, some of them we can avoid, Bill, because you deal with California probate, like the probate fees. What I just tell clients, because I'm here in Texas, we don't have those. What is it? 3% fees to the executor and the attorney, or something like that.
Right. In California, there's a structure fees, 4% the first 100,000, 3 the next 100, 2 the next, and 100 everything else thereafter. $1 million state, $23,000 to the attorney. That's the maximum statutory fees. You can charge less, but that's the maximum. But the administrator also can charge the exact same amount by law, and the court will likely approve on a standard probate those maximum fees. Yeah, so it'll be $46,000 in $1 million state.
Right, which is, it's great, but most of the time, there's not $23,000 worth of work to do, even if we're, chauffeuring clients around. For $1 million estate, that's a house, a bank account, and maybe a 401k or an IRA.
Right.
That's a deed and some paperwork, and we're done. So thinking through that, even if it's not those costs, well, what can we, what are those costs that are hiding in there? Taxes are one of them, whether it's estate and gift tax or just income tax. How can we set things up so that we're not kind of walking into these storms? Again, you're going to have to pay income tax on things. But if you've got an IRA or a 401k that is going to be taxed to the beneficiary when there's a distribution, well, what if you had charitable motivations instead? And instead of the $100,000 going to a beneficiary who's going to pay 23,000 or whatever in tax, and so they net out 77. Instead, looking at it as, well, we can leave that to the charity, whoever that is, and the charity gets 100,000 of the 100,000 because they're tax exempt.
Right.
And so thinking about those kind of potential costs that are out there.
Right. Well, with charities also, I think you can give assets that are appreciated greatly, and then you're not paying the taxes on it. They would. So if you buy $10,000 with a stock, and it appreciates $100,000, if you give it to the charity, you get the $100,000 write-off. If you were to take the $100,000, you have to pay the taxes on it. So it's one of those ways we really avoid the whole tax situation as well as with proper planning. And then the probate costs in California, we have filing fees, we have advertising, publication fees, and then that's assuming everything goes well. In California, people say to me often, well, a trust or estate plan will avoid probate, right? And I'll say, well, many times, yes, but there still is the prospects of estate planning requiring some sort of litigation, whether it be beneficiaries objecting, there still are some potential costs down the road.
Right. And, the cost of that litigation also rolls into the next one of fights. And again, it's easy to think of the fight among the family members who don't like what they're getting. And so on the front end, when they're coming in for the planning, helping suss out, are there potential fights that we need to be thinking about for you and your family? I generally am willing to take the word of my clients when it comes to this. Like, are the kids going to get along if we put, there's Billy and Susie and Jimmy, and we only put Jimmy in charge? Billy and Susie going to be okay with that? Or is there going to be a fight? And I don't know. There's not a right answer, but we're going to go with whatever the client says. Most of the time, they'll be fine. But just
many times they assess and they're correct, but boy, you put money in front of people and you have somebody dividing it up. It's kind of like cutting a piece of cake when you're a kid. Everybody's fine when you watch your brother cut that cake. Hey, come on, move it over a little bit there, right? That's kind of how estate planning can look.
Right. And just how do we make sure, if somebody's going to be upset because they weren't chosen or they're getting the wrong chair or whatever it is, on the front end, on the planning side, how can we figure out, is there a way to step around that to avoid that landmine?
And then also, who's in charge of it? The administrator of the estate or the successor trustee to an estate is a major issue when you deal with who the people are. I find often people assume, well, the sibling who's most successful, maybe in business, is the obvious choice. The problem there is they might be too busy to communicate effectively. They might make all the right decisions, but every husband I think in the world knows, you can make the right decision, but if your wife doesn't agree with it, it becomes the wrong decision right away, right? So same with estate planning, that you can be right about things, but then you end up in fighting. So how do you advise clients to pick the right person of the three siblings? Who's the right person most of the time, or more often, to be the successor trustee?
Yeah, I mean, this is where it's the conversation with them about, who's here locally, because that's obviously going to be a factor in it. Who's going to have the bandwidth for it? I've had several times, like you've mentioned, like the most successful one may not have the bandwidth to do it, and it's just going to be a headache for them to try and make that work with their life.
Right.
Just who has the skill set for it. It may be this person is the hard charging person, but they're just not going to be able to manage things and keep everybody happy while everything else is going on. Right.
And then now, do you work in California? We have a licensed position called a licensed professional fiduciary, where an estate and a beneficiary or successor trustee can hire somebody to act on behalf of the state to make those decisions. Theoretically, somebody who's professional, knows the material, and is skilled at mediating or presenting things in a way. Is that as common in Texas as it is in California? Is that common in larger states? Do you work with fiduciaries, or is that not necessary?
So, I mean, we do have professional fiduciaries. Those would be the corporate fiduciaries, where they are supposedly above everything. Occasionally we do get those as clients. There's not anything for individual fiduciaries. So, anybody who wants to can go be a trustee or an executor if everybody else agrees. There's no requirement that, if you're not a family member or something like that. As far as I know, I haven't even heard anything about setting up any sort of certification like that.
Well, I don't think there is, other than California, of course, we have regulations. But I guess my question more is, are there times that maybe there's multiple choices that you would recommend, say, an attorney to be the successor trustee on behalf of the state, or an accountant, or somebody else who has some professional experience is appropriate?
Oh, definitely. And that's where, again, talking about who's getting things. For a lot of my clients, it's we start with the assumption that eventually your children should be capable of managing this themselves. And just, again, trying to get them to tell us about their capabilities. If we left this to them, are you okay with them doing that? Obviously, if they're 3 or 5 or 18 or even 35, yeah, they may not have the maturity yet that you're looking for. But down the line, eventually we're kind of assuming that the kids will grow into the ability to manage their own share. It's just easier. We avoid a lot of other headaches of fights between the corporate fiduciary and the kids. That said, one of the things that I also think about is if there's too much money, it may not be worth it. If there's $20 million and those kids have never seen that much before, we may want a corporate in there just to help them kind of deal with the initial rush, because we don't want it coming in and then going right back out.
Yeah, I'm on a recent state, like a $40 million state, where there's a company and then there's property and there's securities. The bank they were using went out of business, so we're in the middle of that transition where Chase was buying them and they wouldn't release any money. And it brought the professional and me and the attorney to our knees trying to keep it all spinning, and we made it work. Right. But to a lay person who's not used to communicating and moving quickly, it would have been too much. And so in this case, the trust was well served to have somebody. So now I imagine, though, in this case, when we talk about family fights, that you as an attorney, on one hand, you have to have the technical knowledge to know the law and how to structure the estate and the proper documents, make sure the documents are executed right. But I imagine there's a premium for your success based on your soft skills, your ability to communicate with the various parties, make sure and make a recommendation based on that.
Yeah, well, this is where lawyers, obviously, there are a lot of us out here doing this work. Clients get a choice. I'm sitting here in jeans and collared shirt, but I have not worn a tie to work in years, and I don't miss it. People who are looking for that more formal experience have plenty of options. And so, yeah, it's part of how I see it. Like, again, going back to the 4 Horsemen, nobody else that I know of is kind of trying to have a little bit of fun with this, and our clients seem to like that. Again, you can get stuffy anywhere else if you want. Again, we're trying to make it easy for everybody to understand. And the side benefit of it is, the more I explain it to clients, the easier it is to onboard new employees, so that they understand what's going on.
Right, and the more like you they are, then the more the customers are going to connect with them. So it becomes a virtuous cycle. Right. So the first problem or potential, I guess really the first horseman of the apocalypse was cost. Second was family fights. Third is loss of assets, and how to protect your treasure you put. One is, I imagine when you do the estate plan, it's important to kind of identify as much as you can everything, and then have some system to update the appropriate party. So what does that look like? Obviously, initially, it's pretty easy, right? You ask your customer, and they give you a list, and hopefully they're thorough. But what's it look like as time goes on, and they're hopefully accumulating more assets, or banks change names, or they sell or buy property? What's that look like as an ongoing basis?
Yeah, you're right. When the clients come in for planning for themselves, it's very easy. We can ask them everything. Here, tell us more about this. Where have you hidden this? Is there anything else? It sure does seem simple when clients are right here in front of us. We know where everything is and we can go get it. The problem is if somebody dies, if mom dies and the daughter comes in and they didn't have any planning or know really anything other than here's the will. What do we do then? And, hopefully we can find some statements, but again, there's no guarantee anymore that people are getting paper statements on where their stuff is. Right. And so, kind of going back through records to determine, well, was there any life insurance? I've heard that there's a way to start searching online for life insurance, but It doesn't mean you're going to pull up the 401k or the IRA they set up and had a couple $1,000s with years ago. There's
Right.
just so many different things to find out there.
Right. I've had attorneys work with different errors research companies where they'll hire somebody on a contingency basis and they'll find errors to an estate. And I've also had others that the error hires saying we think there's more assets, we just don't know where they are, and they can help identify them. One of the challenges also, you mentioned the paperwork. Well, also who has the authority to request the paperwork? Because when somebody passes, if the account's the name of the decedent only, then really nobody has the right to get a bank statement or a mortgage statement or insurance statement. In a trust, theoretically, you have a successor trustee, you provide the death cert, and that becomes more smooth. That's another reason why to do that kind of planning. When somebody has just a will, what's the process like to get the documents? I guess power of attorney expires with the decedent, I would think. So how would somebody be able to get those assets?
So again, so part of our process is, sitting down with clients, putting everything in an Excel spreadsheet of at least as far as this date, we knew what it was. Here are the recommendations we had on, either titling, beneficiary designations, what to do with it. Again, creating that as our initial way of trying to find where things are, because if we can't find it later, there's really no good answer. And again, you could lose those things, and people worked hard for it. Some of it's easy to find, like you can go find my collections at my house right now. People know where I live, but I always think back, I know where my sister does her banking only because she and I use the same bank. Beyond that, I have no idea where any of her stuff really is. Wow. Or where to go find it.
It's scary. I recently had a medical procedure, and it was kind of routine, but planned ahead, but I was going to go under general anesthesia. And so I made sure everything was kind of updated again recently, and where the folders were, and shared it with my son-in-law and my wife. So I'm telling my wife things, and she's like, "Really? Oh, wow, really?" I'm like, "Hold on, how do you not know this? You signed the papers for this account, you signed the papers for this part. What do you mean you don't know this?" And the answer is, we're all busy, and we just, I told her 2 years ago we moved our stocks from this company to that company, but unless there's a statement in the house, she'd have no idea where to find it. She really wouldn't have no idea. I mean, maybe they log in my email and find information, but it is interesting how we assume people know things, or we assume they can find things, but that's not always the case.
Right.
And then one of the things you mentioned, if you go into the fourth area, delays and frustration, you talk about the importance of keeping these things up to date and reviewing them. So as a general rule, with somebody, let's say with a basic estate, $1 million or more, house, some stocks, bonds, IRAs, 401ks, that kind of stuff, standard family situation. How often do they need to evaluate this? Once they do the plan, are they set? Do they need to come back every 5-10 years? Do the laws change here?
I mean, what I tell people is there's, the 3 to 5 year rule is probably when I'll see you again, because something will have changed. And those changes break down into, one, the people have changed, whether somebody named in the plan shouldn't be in the plan anymore. It passed on, they're not appropriate for whatever reason, they shouldn't be in there anymore. Or you've got a new person to add in, and better executor, better successor trustee, new child. Something will happen with people. Something may happen with your assets. Again, I don't care that they've bought 2 new shares of IBM and sold 3 shares of Apple. What I think about is, did you acquire a new house out of state that we need to think about? Do we need to worry that now that you've got this new business, that needs to be worked into your plan somehow? Do we need a buy-sell agreement, some sort of transition plan, succession plan for that? Just new assets in or out. And then kind of the large fluctuation in values. The estate tax exemption is so high right now that a lot of people really aren't concerned about estate tax. But it's possible that the planning that was done before, well, you may have a blended family where the marital exemption was going to the spouse and everything else was getting left to the kids. That may mean, the marital exemption right now may be 0, and that may not be what you want. And so those sorts of legal changes are things to think about.
I think it's always something, and it's good to stay in touch from time to time. And I think that's up to the customer to, on one hand, evaluate. But I think as professionals, attorneys are I think should be encouraged to inform us of changes in the laws and changes of the procedures, technology, systems, and then we as customers go, hey, that reminds me, I just got married, I just got divorced, I just have a new kid. I mean, and I think that that's the power of education in media. It makes us, and that's why I do these podcasts, is to talk to thought leaders like you and be able to share the information and encourage people to say, hey, have you thought about those things? If not, reach out to an attorney from Texas, John, and let's ask those questions and better to answer them ahead of time. I think the other thing that's odd is again, to go back to your four horsemen as far as loss, where are the key documents? And I know that I did a podcast episode like this one day, and I was talking to somebody, and literally at that time, the binder I had with my original documents was in this file cabinet right behind me. And I remember pointing to it, and I realized, well, hold on, we just changed stock companies, and I didn't tile it right. I remember I didn't tile it right. I need to fix it. And so I think for all of us, we need to think about these things on a regular basis. And so I guess the question I have, I know you have a great blog, and I see you have some really good content. How do you engage with clients once they're in yours to keep them updated and educated as far as the changes in the market?
Yeah, I mean, this is one of the big problems with estate planning as a practice area is, clients do something, they go off and live their lives, and then a few years later, like, oh, we need to change this. They look at their documents. They can't see, they can't look at it and see who did this. And, every now and again, probably several times a year, we'll get something and, hey, we couldn't remember who did this last time, but here are our old documents. And I'll flip through it. And many times the attorney who drafted their documents is the one who is the notary on some of those documents. It's just like there was their name in black and white stamped at the bottom of the document. And so, how do we keep them around? Well, we keep them around by continuing to provide that content, like what we're doing with our own content. We're sending out monthly emails to clients, potential clients, referral sources. And here's a quick thing. And if you've got a question, jump on my calendar. That's the best way, is just don't let them forget, because if that happens, then of course they're gone. They'll have a harder time of, oh yeah, well, I've got a question. Who do I even ask? I would gladly take that question, and if I'm sending it out to somebody else because it's work I don't want to do, I earn, the benefit is side benefit from the friend I'm sending it to. And so I'd much rather they remember who I am and spend a lot of time trying to figure out how can I unobtrusively keep me in mind for them so that they're not worried about it.
One of the things, a good percentage of our audience is real estate agents. A good number are real estate agents. A good percentage is real estate agents. And the reason I did this, my thesis was that we as agents, we often see customers, whether they are missing an estate plan, because we look at the public record, how the title is held, or if they're a buyer, we ask the question, how do you plan on taking title? Husband, wife, there's different ways here in California to do that. Or do you have a trust? You have one established? It might be a good time to think about it. Maybe you want to do it or not based on where you are. And to reach out to attorneys to say, hey, I have a customer who needs a trust. They bought a house from me 2 years ago. It's still not. They said they're going to. Or I have a buyer who's interested and they want to know the issues. And so do you work with real estate agents? And what does that look like in terms of a regular workflow if they are? And if not, how can we get real estate agents to reach out to you when they have customers with needs?
Yeah, and this is where we do get referrals and requests from real estate agents. Typically it's, somebody has died, the owner has died, and we're trying to sell the property. Now what do we do? And unfortunately, if that comes in, we've got a closing in 2 weeks. We need to get this ready to go. I'm very sorry. There's just no way that's going to happen. And it's not that we don't want to put things together, but we've got, even in the best of circumstances here in Harris County, where Houston is, it's probably a 6-week wait for a court hearing. And it's a low intensity hearing. And at that point, our executor will be empowered to sell the property. But again, minimum 6-week wait. If there's no will, it's probably more like 6 months. And again, people don't want to hear that. So, how do we think about it? Well, the sorts of things that we want to do is just obviously having a better plan in place. Nobody can plan on death for the most part. But what I do with my clients is just making sure when they come in and sign, even if we're not doing a revocable trust, we still have transfer on death deeds to make sure that the property is going to surviving spouse. It's going to be transferred automatically to the trustee under the will. And taking that one step out, because sure, they're probably going to sell their house before they die, but at least we've gotten that step done now.
Right. I think oftentimes, when buyers are buying a house who don't have an estate plan set up, on one hand, it'd be ideal to do it while shopping, because when you buy the property, you tile it correctly and you have title insurance of it being tiled correctly. That said, there's a lot of work involved in the estate plan, and there's a lot of work involved in buying a house. And so you put those two together, it becomes a difficult time to get it done. But to all the realtors listening, I would say certainly would have the discussion and at least make the introduction and get it on the list of things to do. If not, getting it done beforehand, and or contributing to the process, making it easier, providing the documents to the attorney and things like that can be helpful to you. So again, that's why I did this podcast initially, was and why I've invited on estate planning attorneys as opposed to just probate attorneys, because we want to be part of the solution, not just helping fix up the problem when there's a problem at the end. So John, obviously we had recently, as we record this, the passage of the One Big Beautiful Bill that I think extended the prior limits, meaning the Armageddon of potential has been, at least on that issue, we can talk about, I'm not here to talk about the politics, but on the issue of the exemption for an estate, that's just been reset for another 10 years. So were there people who made plans in the interim assuming it would go away that you have to rewrite, or is it just primarily we all kind of assumed it would be rewritten at the same numbers and we're glad to see that done?
Yeah, and so I was telling my clients who were in the zone where if it was going to be extended or not, it would make a difference for them. Like, we need to wait until August. What I'd heard was, if they don't have something done by August, they don't expect anything to happen, because people will come back from the August recess and then they're gearing up for next year's elections.
Right.
So everybody would have been dug in. So my clients who were in the middle, it would affect them. I was telling them, look, we can wait. I don't want you to worry about being forgotten, because we have you're in line now in front of the people who are going to show up, right around Thanksgiving,
right.
Panicked.
Right.
And at that point, we may have to tell them no. But, it really was here, we're going to look at this situation for you. If it gets extended, you'll be fine, in which case we don't need to overdo anything, and it's just easier for me to not oversell and keep it tamped down. Look, I would love to take your money, but right now I can't justify that this is really going to be necessary. If it drops, don't worry. You're in line. We kind of know what we need to do. We're not going to have to start from scratch, but we'll have to work quickly on that. And so it was just unfortunately, clients, I'd love to give you a straight answer, but Congress has not given us a straight answer. And so we've got to kind of wait it out.
And so, I'm sorry, so we're still waiting it out, or?
Oh, no.
We're done now.
What it was. We were waiting until we got an answer, and now we have an answer of, if you were in that middle and you didn't really care, well, guess what? You can continue to not have any big planning to do right now. Doesn't mean there wasn't planning for other people who wanted to do it anyway.
Or other things, or other issues, but I think on that issue, Lisa, it's not. Yet it's still a good reminder. Hey, is my plan up to date? And let's go through real quick. Do I have the same business, the same property, same people, same relationships? And if not, give your attorney a call, give John a call, and make sure you're on the same page. So, well, it certainly was interesting. A lot of excitement about potential work, and I know a lot of attorneys kind of lining up on bigger estates and how to, what some of the creative answers were. But it looks like that's kind of blown over. John, it's always a good time to talk to an attorney who can help you. In your case, being licensed in Texas, best way to get a hold of you, I think we have on the screen, is your 713 number, 714-1249, or you can go to the website, strohmeyerlaw.com. You go there, you can learn about the 4 Horsemen of the Apocalypse of estate planning, and or set an appointment to talk to your staff. What's the intake look like? Somebody has a question, they go on there, they set an appointment, they talk to you or an assistant, or what's that process
they'll be
look like?
talking to our intake team, and so they'll get some kind of basic information, make sure that we can do the work they're looking for. A lot of times, today we got a question, hey, can you help us with the guardianship? We cannot, but we have lots of people we send that out to, and happy to get people to the right place.
Very good. Well, again, there's a phone number and website on the page. And of course, if ever you lose that information, feel free to reach out to me. John, thank you so much for joining us today and offering your information and the service that you do on a regular basis.
Of course, Bill. Thanks for having me on.
Thank you. And for the rest of you, this is Probate Weekly. We get together, we can talk about probate or avoiding probate, which is with proper estate planning. We talk to attorneys and professionals across the country. If you want to continue the conversation, you go to our Facebook group, probateweekly.com in Facebook, and there you can ask for referrals for if you're looking for an attorney or a realtor or other vendors across the country, as well as look for referrals in business across the country. Love to have you participate. Was this helpful today? Give me your comments, thumbs up, comments, questions. Reach out to me on Matt Bill Gross Probate on social media. As always, make today your best day ever.